Great. So thank you for joining us for this month's webcast, which is about the upcoming ban on fire and rehire. I think Dawn's just put a link in the chat to our next session, which is going to focus on that Supreme Court ruling. So we've titled it "What's a Woman?" So we can be nice and contentious with the title, and then obviously go into the more solid legal understanding of what that ruling is, what it means, and what as employers you might need to be doing or things that you might need to think about. So going to be a really good session, probably going to be quite technical as well. So as always, we'll be recording these sessions so that you can watch them again afterwards. So what we're going through today, we're going to be about half an hour. We're going to go through the upcoming changes that we're going to be having under the Employment Rights Bill in relation to fire and rehire. For those of you who've been on sessions with me before, or perhaps seen my postings on LinkedIn, you'll know that when it comes to the Employment Rights Bill, I am taking a bit of a backseat approach to this. We're not selling sessions or selling training about the Employment Rights Bill because there's so much yet that is still got to be updated, potentially changed. It's still making its way through Parliament. So we haven't had that final legislation yet. And also, there's so much of the legislation that's then going to depend on later regulations, which have yet to be written. Oh, did I do that? Oh, okay. As such, there's lots of stuff that we're being very vague about. Now, the ban on fire and rehire is not one of the ones that we are vague on. This is one where we think that actually, as it's currently drafted, this is pretty much how it's going to come in, subject to some minor tweaks here and there. And it is something that's going to require quite a bit of preparation, which is why we are doing this session on it, and we'll probably do further sessions on this nearer the time. So what is fire and rehire? Well, the definition is where we dismiss someone and then offer to rehire them, usually on less favourable terms. Why would we do this? Well, typically it's where we want to change someone's contract of employment. They've got some benefits or some entitlements or some terms that we're not particularly happy with anymore, or our business reasons mean that we now need a change of practice. Their rights are enshrined in the contract. We need to try and change them. Employee won't agree. So we terminate the contract and offer a new one on the new terms. So that's what we mean by fire and rehire. It's often used during restructuring, where we've got cost-cutting measures going on, or where we've got attempts to modify contractual terms because we don't like them. So we sometimes see this where we have had TUPE transfers as well, where people want to level up their terms. Dawn, just a really quick note. Michelle's trying to access the webcast. Would you mind sending her a link, please? Sorry about that. We'll carry on. So implementation, so this is usually following unsuccessful attempts to gain employee consent for contractual change. So where we've tried to negotiate with employees, they're not agreeing. So we revert to, well, we're going to terminate your contract and we're going to rehire you on new terms. I say that it's often after an unsuccessful attempt to negotiate. Sometimes that doesn't even happen. So when we look at the P&O scandal, where we had 800 people who were terminated, there were very few or no attempts in some instances of efforts to negotiate with those people. They were simply dismissed and offered their new contracts. So why is this change happening? As I've referenced there, the P&O scandal, sometimes referred to as a P&O disaster, which makes it sound like the ship sank. It didn't. They fired 800 people instead, without notice and without consultation. There was a huge uproar at the time. The unions were furious that this happened. And senior management at P&O Ferries did this knowing full well that it was illegal and basically not caring about the consequences. So there was a huge public outrage. There was lots of media coverage and lots of condemnation across the political spectrum. It resulted in a parliamentary inquiry, and I think this is actually still rumbling on as well. The government response, we saw an increased pressure on lawmakers to introduce stronger worker protections. So the Conservative government started making some headway with this. And then what we're seeing now under the Labour government is that being taken even further through an outright ban. But we are going to come on to what the Conservatives have brought in, because that is what we're currently operating with, before we then talk about what's coming further down the line. So the current legal framework, we don't have a total ban. It's not legal to do this. To terminate someone's contract without consultation and without a fair reason is illegal. It's an unfair dismissal. Um, so where we say it's currently permissible, what we mean here is we do it, we offer the new contractual terms, knowing that if someone were to bring tribunal proceedings and claim unfair dismissal, that where we have a reasonably comparable role that we have offered under those new terms, that a tribunal is unlikely to pay that individual or order that we have to pay that individual any compensation. So they might get their unfair dismissal judgment that they can put on their mantelpiece, but financially it means nothing. And what we see is that we get these individuals, they'll go see lawyers, they're told your case isn't really worth anything, your comparable terms are reasonable, it's a reasonable effort to mitigate your losses, you're unlikely to be awarded any compensation. So actually, when it comes to currently legal recompense around this, whilst we see it as an option when it comes to wanting to change contracts of employment, and it's almost become a bit of an urban myth that it's legal, we see it as being a practice that's generally permissible as long as we follow a proper process. And actually, you'll see instances where tribunal judges don't actually criticise employers for terminating the contracts and offering the new ones. So it has generated this sort of culture where it's seen to be legal but risky. So we then had Code of Practice that was introduced on July 2024, which provides guidance only. So if you want to go through the process of firing and rehiring, there is now a code of practice that we have to follow. If we don't follow that code of practice, then the tribunal will consider that, and often it will impact compensation awards. So there's a 25% uplift. What that code of practice provides for is that we have to make sure that we go through a meaningful consultation, that we notify ACAS that this is going on, and that we're not threatening termination unreasonably early. We have to be seen to be exhausting that consultation effort before we then say, well, look, actually, if we can't get to agreement on this, then we are going to be terminating your contract and offering you new terms. Problems and criticism that come from this. So companies facing public backlash, and there's employee distrust after these tactics have been used. It can impact workforce morale. We've seen increasing political pressure and significant union opposition. Now, the Employment Rights Bill, so this was introduced in 2024 by the Labour government as part of a broader package of worker protections that is being brought in. You're probably sick to death of seeing stuff on LinkedIn or seeing employment lawyers and HR people talking about this, because it's being talked about nonstop and people are selling training courses left, right and centre on this, which in reality aren't really adding any value to you because it's still in the House of Lords. We still don't have that final wording. And as I said at the beginning, we don't have the final regulations either that are going to give us the clarity that we need. However, the provisions in relation to fire and rehire have come out so far relatively unscathed, and there does seem to be cross-party support for this. So when we compare this to things like the removal of 0 hours contracts and the day one employment rights, which are very contentious, there's lots of detail that needs to be thought out around those. The fire and rehire stuff is generally seen by most people to be a reasonable step, and there hasn't been a huge amount of opposition, so we haven't seen much in the way of amendment, which is why we're relatively confident that it's going to be coming in the way that it's currently drafted. So the legislative aim here is to close the loopholes that allow employers to bypass those fair dismissal protections. So where we're offering a rehire that it's seen as effective mitigation, as long as that we have been reasonable, then it's unlikely that an employer would be pinged for it. This is going to totally turn that regime on its head, where it will become an automatic unfair dismissal if we take someone down a fire and rehire process. So if you've been on sessions with me before or even had advice from me, when we're talking about things like someone who's dismissed for making a whistle blow, or if someone were dismissed in relation to requesting a statutory right. So say, for example, if someone asked you for their contract of employment, it's a statutory right, and we go, you sound like a troublemaker, I'm dismissing you. That would be an automatic unfair dismissal. So where you have someone who is employed less than 2 years, this is the current loophole. So if someone were to be taken down a fire and rehire route with less than 2 years employment under the new regime, it would be an automatic unfair dismissal. They wouldn't need that 2 years service. And it's also going to be much, much harder for an employer to defend, because the boot's on the other foot. We're starting from the position that the dismissal is unfair, and we're going to have to talk it down the other way. So we've got a poll that's just gone up on the chat. So if you want to have a look at that. So how significantly will the new legislation impact your HR or any restructuring plans that you may have? First option, major impact. We use these practices regularly when it comes to fire and rehire. Some impact, we've considered it in the past. Minimal impact, because we've rarely, or it's never been relevant for us, or we're not too sure. Okay, so some impact, minimal impact, so rarely or never relevant, and unsure. I'd say this is probably sort of, with the experience that I have with my clients, I'd say the proportions probably fall in a similar sort of range. So we're seeing half of you minimal impact. I'd like to think that fire and rehire is used as the exception rather than the rule, rather than something that's being used regularly. If this is being used regularly, our contracts are not up to scratch. They're not reflecting the way that we actually work. And for most employers, fire and rehire is something that they might only have to do once or twice in the entire time that they are running a business. If we're doing it more often than that, then we've got problems. The issue that we've now got is that if on that one occasion we need to do it, it's becoming a much more difficult exercise to do because of the way that the law is changing. So the main legislative changes, it's going to be an automatic unfair dismissal. So if we fire someone who refuses new terms, even where we offer the new contract, that will be automatically unfair. It covers fire and replace, so where we fire someone and replace them with somebody else if they refuse the new terms. And there's very, very limited defences, which I'm going to come on to in a moment. So currently, where we are looking at things like restructuring or levelling up terms, or perhaps we've got a benefit that is no longer affordable, then we can present justification for the changes. So it might be that we've got financial reasons or fairness reasons, or general business reasons why we're doing something. The majority of those defenses are disappearing, and we're going to be left with one, which will essentially be unobtainable unless your business is closing. So the exception will be where we have a genuine financial crisis. So this is where there is an existential threat to your business, and the business must be able to prove that it is at the point of imminent business failure. So this is not, oh, this is financially unaffordable to us, we need to remove this element of holiday, or we want to remove, this percentage of your pension payments because in the long term it's unaffordable, or actually we're going to struggle to pay some of our bills, or we've got cash flow problems. That won't be enough. It has to be imminent business financial failure. We'd have to show evidence showing that we are in severe financial distress. We must be able to demonstrate that there are no other alternatives, that every other option has been exhausted. And it's a very, very narrow interpretation. So what we're likely to see here, that you need to be at near insolvency to be able to use this exception. Now, for anyone who's ever been through an insolvency situation or is familiar with them, sometimes you get to the point of no return. And the way that I'm sort of reading this is it's almost going to come too late, that if we are relying on fire and rehire at the point of near insolvency, it's going to make very, very little difference to that insolvency outcome. And if anything, it's going to kick it down the road by perhaps at best a few weeks, depending on obviously that business situation. So as I said, I think this is an exception that is going to be very, very rarely relied upon, purely because of how inaccessible it is. If we get it wrong, there's penalties for non-compliance. So the maximum unfair dismissal award, we're looking at over 124,000 for a long-serving employee. The protective award, so if we get something wrong, the protective award was a 90-day award. So say, for example, if you failed to collectively consult, if we've got a redundancy situation, there's a protective award of 90 days. That is now being doubled. So for every employee that you do this to, you could be looking at 180 days pay in addition to your basic award and the compensatory award, plus the 25% uplift. So these are significant financial penalties. When we talk about financial penalties and compensation, we often talk about unfair dismissal as sort of being, the limp younger sibling of discrimination. Discrimination's the big guy in town. There's no cap on those awards. We talk about the massive awards in that area. We talk about hundreds of thousands and potentially even millions of pounds worth of awards when it comes to discrimination. Unfair dismissal, we often talk about it in the terms of, well, average award is around 7 grand. Your legal fees are probably going to be between 7 and 10. Yes, it's a lot of money, but it's not actually something that's going to be business critical. Once we start stacking this up, even if even if your basic award isn't anywhere near that 124,000, once you start stacking on that 180 days and the 25% uplift, this is starting to look like something that's much more considerable. And particularly if you're doing fire and rehire because you have got financial issues going on, this could be something that could have an enormous implication for you, particularly if you're paying legal fees on top of it. So our obligations for consultation notification, we're still going to have to go through this. So even if we're at this point where we've got that genuine financial crisis, it's not just a case of being able to fire and rehire. We still have to go through consultation and notification. So again, if we're at that point where we're at an existential crisis and we've still got to go through potentially collective consultation, this isn't something that's going to happen overnight. And it could well be that the business closes or goes insolvent before this is finished. So we still have to make the ACAS notification as we do under the current code of practice, and written notice will be required when we're looking at 15 or more employees that are facing contractual changes that could trigger dismissal. Collective consultation for where we've got 20 plus potential dismissals. And as we hopefully all know, that where we've got between 20 and 99 employees who are affected, we've got to have that 30-day consultation period before the first termination. If it's more than 100 employees, it's a 45-day minimum consultation period. We also have to have individual consultation, so meaningful dialogue with affected employees, regardless of the numbers. So this is not a small endeavour. If we're having to go through this, this is real consultation. We've got to show that we've been very proactive, we've front-loaded with information, we've gone through all of the best practice things that hopefully we know that we should be doing under collective consultation or ordinary consultation, because ultimately, even if you're in an existential financial crisis, if you haven't gone through the correct process, you could still be pinged on an unfair dismissal for an incorrect procedure. So what we can and can't do at the moment. So at the moment, we technically cannot force unilateral contract changes. So what I said at the beginning about this kind of the urban myth that this is legal, it's still a unilateral change of contract where we're forcing a change on someone who hasn't agreed to it. We're in breach of contract. However, where we're offering new comparable terms, we've got valid mitigation, and provided we've been fair and reasonable, we're unlikely to get pinged by a tribunal judge. We can currently dismiss, as I've said, under that kind of culture that we've grown for we can dismiss for refusing new terms, and we can use dismissal as a threat during negotiations as long as we don't do it too early under the code of practice, and we can replace staff who reject the changes. What we can do, we can seek voluntary agreement, we can offer incentives for consent, and we can demonstrate genuine financial crisis, and we can consult meaningfully with staff. Going forward, so what we won't be able to do, we will not be able to force unilateral contract changes. We won't be able to dismiss someone for refusing new terms. We won't be able to use dismissal threats during negotiation, and we won't be able to replace staff who reject those changes under the new regime. It will have to be, as we've said, that existential financial crisis. We will have to be able to evidence that, and we will have to have gone through a full consultation and negotiation exercise. So how confident are you in your current employment contracts? Because this is going to be the big question. Are we going to be satisfied that our contracts can stand up to years of business without us needing to change them in the future? Because this is what this is all about. We are no longer going to be able to be as flexible with our documentation with people who have already started employment with us. So we are going to need to be really, really confident that the terms that we have in those contracts are business safe for us for the foreseeable future. So in the poll here, we've got very confident, audit ready. That's fantastic. Somewhat confident, but we need a review. Not confident, overdue for updates. And we don't currently have formal procedures or contracts. So we've got a 50-50 split there. Oh, it's moving a little bit, maybe because I sort of reinforced the point about, if you give someone that contract, that's it for the next 10, 15 years that they're employed by you? Are we confident that that contract can stay in place and we're not going to need to change it? So we've had someone drop into the not confident there. I'd say yes, some people are generally somewhat confident in their contracts, but definitely we need to think about how we future-proof these agreements. So, alternatives to fire and rehire, we can still get voluntary agreement for people to change their contract. So, if we can get someone to agree through negotiation and incentives, we can change them in that way. Restructuring, so redesigning roles and departments rather than changing terms. So, that could mean that we end up going through redundancy exercises, particularly where we identify efficiencies or we're creating new roles. So there's still a consultation requirement there and the requirement for us to be fair. Innovation, so finding efficiency improvements that don't require contractual change, so finding other ways to save money if they were around financial changes. And phased implementation, so gradual introduction of changes with transitional support. So not doing big changes all at once, that we go through things in a phased consultative approach, and where potentially we're offering incentives as well for those changes. So using the carrot rather than the stick. Industries that we think are going to be the most impacted. So this has been cut off from the bottom, so I'm going to try and do these from memory. You probably won't be surprised that I think this one is retail. So retail, as we know, ever moving beast, depending on what the economic climate is like, how much money people have to spend, how recruitment is going, and what the market is like generally. Retail typically need very, very flexible terms. Hospitality, so I think was the next one. Again, there should be no surprise there. And then in terms of the rest of them, I'm not even going to hazard a guess at these. However, from memory, what was on the list? So we have retail, hospitality, tech. Dawn might want to prompt me here before I forget the others, but we'll circulate the slides afterwards anyway, that will have them all on the bottom. But typically anything that is going to be particularly impacted by the political climate, the international climate. So often, I think what was on the list here was financial services. So where there is a lot of movement internationally and where things are impacted economically or politically, that is generally where we see organizations that need those flexibility of their terms. So key steps, what should we be doing? Well, auditing. First of all, let's review our existing policies, contracts, and have a look at what our change procedures currently are. Go through your contracts with a fine tooth comb. Have a think, is there anything in here that I think I might need to change? Have a look at the global climate. Have a look at how easy it is to recruit people, what the talent pool is like, what your current workforce is like. What are the issues that you are currently facing that you think, actually, you know what, if this was in a contract or a policy, this is something I think I could solve. If you're not sure, if there's some gaps in your knowledge or you're struggling to kind of connect those dots, take some advice from your legal advisor. So have your contracts reviewed and say, look, we need to make sure that these are future-proofed. Now, what I don't want you to fall foul of is anyone who is selling you a clause that says, aha, I have a perfect variation clause where if you put this in the contract, it means you can vary any of the terms and it gets you around fire and rehire. No, it doesn't. Variation terms have always had a limited impact, and generally they have always been held in a legal environment to be restricted to minor tweaks and updates to a contract. It is very, very difficult to rely on a variation clause for substantial changes, particularly where it puts the employee in a worse off position. Also, what you've got to think is when the Employment Rights Bill comes in, trade unions are going to have much more access to your workplace. It's going to be much easier for your workplace to become unionised. And the difficulty is if we're overly reliant on variation clauses and we're upsetting our workforce, then that's going to start research into trade unions, trade union membership, and they'll realise how easy it is to get trade unions into the workplace. And they are not going to tolerate you relying on variation clauses. So before you end end up down a big dark hole with a trade union. Let's audit our contracts. Let's look at how we can future-proof things, and let's review our policies and also what our change procedures are. If we're relying on this lots, which I think most of the people on here are not doing from the poll, we need to be thinking about why we're doing that. Why aren't the contracts right in the first place? We need to look at educating people. So training for yourselves if you're HR, or if you've got HR in your business, training for them, and also training for managers on what we can and what we can't do. We don't want bullshit managers strutting around the workforce telling people that if they don't like change, well, they can bugger off somewhere else, because that isn't going to fly anymore. We're not going to be able to do that. Documentation, so we need to make sure that we're really, really strong on our record keeping where we are going through consultation and processes. So maybe think about getting some processes set up, so if you need to do this, so you've got your template letters, you know what you'll be doing and the process that you'll be going through, and you've got something to follow, so that when you are at one of these crunch points, you've got that crutch ready for you. And engaging, developing stronger employee relationships. This is really, really important. If you can build a culture of trust with your employees when you are really, really under pressure and you need to make changes in the interest of the business and the interest of the future of the business, if you've got a good relationship with your employees, they're more likely to help you and agree with those changes. So think about your culture, think about how you can develop those stronger relationships so that you can set those foundations, so that if you need a bit of that kind of mutual support going forwards, that they're more likely to have some empathy with you. So what's your biggest concern about the new fire and rehire ban? So that's the poll. If you want to have a look at that. So we've got risk of tribunals and legal penalties, reduced flexibility in workforce planning, managing employee expectations, and cost and complexity of compliance. So risk of tribunals, that's a big one for everybody at the moment. Tribunals cost a fortune and they're an absolute pain. I have heard, I think that the latest that someone's just been listed for a hearing is 2027. So that's not even getting into a tribunal room till 2027. So it's not so much even just the cost of your legal fees or potentially the compensation down the line. It's that you're going to be living with this as a bit of a nightmare for the next 2 or 3 years. So trying to be as compliant as we can, working on our culture, making sure that we're checking our documentation and we're getting ready for change, particularly because it's going to be so much easier from 2026 for people to bring proceedings. This is all really good preparation that we can be doing. So thank you very much for listening. That's all we've got time for today. I'm happy to take any questions because we've got a couple of minutes before we wrap up, because this does represent a significant shift in our UK employment law. It's going to become more costly and there's going to be more risk of tribunal. And if there is anything specific that you would like to cover, then please don't hesitate to reach out. So first question we've got there. So since the Employment's Right Bill is still in consultation, does this mean we can stick to current legislation for now, which is easier to follow and comes with fewer restrictions? 100%. So you don't need to kind of go, yes, I'm happy to follow the Employment Rights Bill now. The current law is the current law. What this session about, though, is the preparation that we need to be doing in the background, some things that we might need to get ready for the law when it comes in. But if there is anybody telling you that you can no longer use 0 hours contracts, that people have day one rights at the moment, they do not. It's not going to come in until 2026, we think, at the earliest, because the legislation isn't finished. So yeah, great question there. No, we follow the current legislation at the moment. If you're a fan of the webcast, please do leave us a review. Trustpilot as a growing business is really important to us. So please pop on the link that Dawn's put in the chat. If you are also interested in hearing more about what we have to say about HR and employment law, then we do have a podcast. So Dawn has just dropped that link into the bottom as well. So do pop on there and have a look. What we do on the podcast, it's called HRER, is we take real client queries, and myself and my co-host Ollie, we dissect those and have a good chat about all things HR and employment law. We're in the top 20 in the UK for HR podcasts. That is doing quite well. And I think our last one was about an employee had a BBL, so a Brazilian bum lift, had taken the time off sick and hadn't disclosed that it was for something cosmetic. So we do get into some really juicy topics on there. If you need any support with your HR, so if you are a HR consultant, you need legal advice, that's me, I'm your legal advisor. If you're a company that needs HR support, or you're looking for HR software or e-learning, so we have e-learning provision at the moment for sexual harassment and also diversity, equity and inclusion. Please don't hesitate to reach out. We've got so many products out at the moment, and we're so busy that actually we have also recruited into our HR and employment law advisory team. So welcome Michelle to the team. It's her first week this week, and we're thrilled to have her here as well to come and help service our clients. So if you have any HR and employment law needs, you know where we are. Please don't hesitate to reach out. And I hope that we see you all on the next session, which is the Supreme Court ruling, What is a Woman? So thank you very much. That concludes this session, and the recording and slides will be available afterwards. Thank you very much.